Our next case is Statewide Prisoner Extraditions versus Patten.
May it please court. I'm Jonathan Polk here representing the employer carrier, Statewide Prisoner Extraditions and Travelers. I'd ask to reserve 2 minutes for rebuttal. I think this is a very important case because it gives the court an opportunity to do a few things. One, to uphold and honor managed care arrangement procedures. Another one, to curb the potential abuses of self-help, and also to give guidance to employers, carriers, and JCCs regarding these issues that have little case law. For instance, managed care arrangements, I believe, have few cases, and I think we need guidance on that. The facts of this case, I believe, are particularly important. This claimant has a history of workers' compensation accidents, at least one of which was under a managed care arrangement. The claimant had 2 prior cervical fusions, 2 prior lumbar fusions. He had a prior herniation at C7T1, which is at issue in this case. He also had prior treatment at L3-4, which was also at issue in this case. He had neck pain with radiation all the way up until just a few months before the industrial accident. The accident then occurred on July 8, 2008. The claimant was stationary in a van extraditing prisoners. He was seat belted in when another truck struck him. There was differing testimony as to how fast that truck was going, anywhere between 2 and 4 miles per hour. There was no dispute that this was a low-speed collision. The claimant then drove that same night at least 6 hours all the way from Atlanta to Orlando. After the accident, he worked up as much as 115.75 hours per week. He didn't miss.
This has nothing to do with the issues on appeal, does it?
I think it does, Your Honor. There are a few reasons why. I think it has to do with the estoppel argument. He has, for instance, the history of workers' compensation accidents and whether he was somehow asking for medical care during all this time. He was receiving medical care on his own. He was working. So I think that kind of goes against his argument whether he was asking for care and he just couldn't work. The claimant that night, the same night of the accident, treated at Atlanta Medical Center, but he didn't treat for his neck or back for another 3 months thereafter. He was discharged from Atlanta Medical Center and told to follow up with his private medical doctor, not under workers' compensation. The claimant then called his family physician, Dr. Suero, just 3 days after the accident. The claimant never mentioned the accident, never mentioned any neck or back pain. The claimant admitted in his deposition that he knew there was a managed care arrangement in place. The very next day, despite admitting that there was a managed care arrangement in place, he went and obtained unauthorized surgery, namely an L3-4 fusion. Once he finally complied with the grievance procedures and submitted a grievance in December 2009, the EC authorized a primary care physician. Importantly, the claimant never filed a grievance for any specific care before actually undergoing that specific care. It was always the care first and then the grievance second. The JCC said in his final order that the ultimate conclusion was whether the EC was stopped from what he called asserting a managed care defense. I don't think the JCC had any jurisdiction in this matter because the claimant had not exhausted the managed care arrangement procedures. The claimant first filed the grievance in November 2009, more than 9 months after his first PFB, and more than 7 months after his unauthorized surgery. The requirement to first file the grievance.
He couldn't now comply. Under your position, he just waived it forever because he couldn't now comply with the procedures of the managed care. I mean, his condition has been remedied already outside that procedure, correct?
I believe that's correct, Your Honor. For each specific thing that he underwent, I think he had a duty, a burden to go through the managed care procedure, file a grievance. If the grievance was denied, like in Bagan, where the employer carrier just didn't even respond, then file a petition. Then the JCC can hear it. In fact, he did just the opposite. The procedures were obtain the care, file a petition, then file a grievance third, just the opposite of what he should have done. There's a strong public policy supporting reversing the JCC in this case. Otherwise, claimants, I believe, can circumvent the managed care arrangement procedures that the legislature and the ACA have put in place. I think they're there for a reason, and I think it's important that the court uphold those reasons. The claimant prejudiced the EC in his actions. For instance, he obtained very expensive care outside of the state in New Jersey, care that's going to cost 3-4 times as much as it would have cost under the Florida work comp fee schedule. And I think it's also human nature for IMEs, EMAs, doctors to look at care that a claimant has already obtained and say, no, that's not medically necessary, no, that's not causally related, so we're not going to relate that. I think that's
New Jersey expenses, for example, specifically awarded below?
Yes, Your Honor. I believe the JCC did, in fact, authorize Dr. Sharma, and Dr. Sharma was out of state. And he also awarded.
But he awarded, he permitted that after the fact. Is that correct?
Yes, the judge did award that care after the fact. Correct. And that's my point, because and that was going to be my next point. Just as it is difficult for doctors to go back and say something's not medically necessary, something's not causally related, and therefore stick the claimant with the bill, I think it's difficult for a JCC to do the exact same thing. He doesn't want to stick the claimant with hundreds of thousands of dollars in medical bills, and that's human nature. We all feel that way. But that doesn't say that the claimant shouldn't follow the procedures in the first place. It's important to note that once a claimant actually complied with the managed care arrangement procedures, in this case, the EC provided the proper care. Self-help was improper in this case. As I mentioned, the managed care arrangement procedures controlled, so I think the self-help was precluded. Florida Statute 440.13.2c, the self-help section, refers to initial treatment or care required by this section. In other words, it's a separate and distinct section from the managed care arrangement. Managed care arrangement is 441.34. Self-help is 440.13. This isn't a case like Bagan, where the EC failed to mail a managed care packet. In fact, the EC did mail the managed care packet in this case.
When did he mail?
February 17th. February 17th, 2009, Your Honor.
So like 7 months or so after the accident?
Yes, Your Honor. However, that was just 4 days after the carrier was first made aware of this accident via petition. Furthermore, I think Bagan is also distinguishable, and counsel actually authored that opinion, and thankfully it was very detailed in its explanation of why it was denying the managed care defense, I guess as the JCC called it. Number one, there was no managed care packet mailed. There was in this case. Also distinguishable because in Bagan, the employer-carrier never responded to the grievances. In this case, once a claimant finally filed a grievance, which he didn't timely, he underwent the care first, then filed a grievance second, or a grievance third after a petition, then the employer-carrier responded. In Bagan, the claimant grieved, there was no response, then he filed a petition. He went about the procedures the correct way.
Had he ever been injured previously in an accident that was subject to the managed care arrangement?
Yes, Your Honor, that was Daniel Patten.
And did he follow the managed care arrangement in that incident?
As far as I can tell, he did. And that is part of our argument, because I think that goes against the estoppel argument. That case was Daniel Patten v. Rogg, R-O-G-G. And as far as we can tell, it was followed. And I believe he may have had the same counsel in that prior accident as well. Even if the self-help cases apply, and I don't think they apply, the claimant didn't follow the proper procedures under the self-help care provision in 440.13.2c, also supported by the case law. Number one, he didn't make a specific request for any care that he ultimately underwent. For example, the surgery. He never made a specific request for that. He didn't allow the EC a reasonable time to respond. That's the second element. For those two reasons, because he didn't meet the first two elements, it's difficult to determine whether the care was compensable, reasonable, and medically necessary. And that goes back to the argument where I say it's just human nature for judges and doctors to go back and say, no, we're going to say that's not medically necessary. No,
we're trained not to be human.
Sorry, Your Honor?
We're trained not to be human on those kinds of matters.
I understand that. In 440.13.2c, going back to that, it reads that the claimant can receive initial treatment or care, not specialty or extraordinary care. That's important. Initial care. Initial seems to imply primary care physician, things like that. That's not what the claimant did when he used self-help in this case. In fact, he went to specialty physicians, pain management physician, orthopedic surgeon, who in fact actually provided surgery. So there was no initial care that he used under the self-help care provisions. There's a strong public policy, once again, supporting reversing the JCC with regards to self-help. How far should a claimant be able to go in using self-help? I don't think he should be able to go directly to a specialist and obtain specialty care like the surgery. At the very most, a claimant should be able to treat with a primary care physician, and that's the initial treatment or care. If the primary care physician refers the claimant to a specialist, then the claimant should once again have to request that care from the specialist. At the very least, a claimant should have to specifically request surgery or any other extraordinary care. And I think, and claimant may be able to, the claimant's counsel may be able to clarify this, but the claimant seemed to concede the JCC's denial of a surgery in page 44 of his answer brief. And I believe that was an issue that was ripe and due at the hearing, so the claimant now can't plead for it under Florida Statute 440.25.4d. There is no major contributing cause in this case.
Would you agree that if your client waived his right to rely on the managed care agreement that the JCC would have jurisdiction?
Your Honor, to begin with, I don't think we waived that.
No, that's not my question. My question is, would you agree that if your client had waived its rights under the managed care agreement, that the JCC would have jurisdiction?
I think just as in the Perotti case, where they say you can get self-help, get doctors, so long as, or for the period of wrongful denial, I think that standard should apply possibly at most here in this case. In other words, to the extent where you say that we may have waived the managed care arrangement, that should only last during that period where we're not complying. Once the carrier obtained notice of this accident, it sent out the managed care packet and followed the managed care procedures. The claimant didn't. So I think to the extent that we waive it, it's only up until that period where we weren't complying.
Well, the JCC evidently believed that you waived your right to rely on the managed care agreement. Is that correct?
Yes, Your Honor. He said.
And is that a finding of fact or what?
I think it's a finding of law.
What's the standard of review on that?
I think it's a finding of law because he's basically claiming estoppel, and he used those words. Under Mobile Medical Industries v. Quinn, 985 SO2D 33, there are three elements of estoppel. One, a misrepresentation. Two, reliance on the misrepresentation. Three, a detrimental change in position based on the misrepresentation. I don't think the claimant proved, and I don't think the JCC found any one of those three elements. So I don't think there was any estoppel in this case, and I believe that would be subject to de novo review. I think there's no major
argument that, if I understand it, is on these facts, no waiver can legally be said to exist.
That's my argument. There was no waiver in the first place, but to the extent that this Court does find that there was waiver, it should last only for the period where it finds that the employer carrier did not follow the managed care procedures. And I think that period lasts only up until February 17th, 2009, before the claimant ultimately underwent.
Was the employer aware of his injury as opposed to the carrier? Well,
that's interesting. You should ask that. The judge found that the employer was aware. The employer testified no, he never knew that the claimant was requesting medical treatment. He did know about the accident. He admitted to that.
Did he know he had been injured in the accident?
Well, I believe he knew, and I don't want to misrepresent something because I'm not familiar with that specific point, but I believe he knew that there was an accident and that the claimant did treat that night at Atlanta Medical Center. Whether he knew there were any ongoing injuries, I think he said no, because it was his testimony that the claimant did not ask for medical care. The claimant testified otherwise, and the JCC found otherwise. There's no major contributing cause in this accident. Dr. Bills clearly testified that the accident was not the major contributing cause.
So if you can distinguish between the employer and the carrier for these purposes, which you probably can, there would be no reason for the employer to tell him we have managed care because he didn't know that he was asking for care of any kind.
That's our position, Your Honor. Yes, absolutely. That he was not aware of that, and once the carrier was made aware of it, we acted immediately. Dr. Bills clearly testified that the accident was not the major contributing cause of this claimant's cervical condition. Dr. Munson, the claimant's IME, gave two conditions. One, if diagnostic procedure showed prior pathology at C7T1, then that would change his position. There was, in fact, prior pathology at C7-T1, so that first condition was met, no major contributing cause. Second condition, Dr. Munson testified that the cervical condition developed at the onset of arm pain. There was arm pain up until at least 8 months before the industrial accident. The second condition was met. The claimant told Dr. Munson, however, that his arm pain began on the date of the accident. Both of Dr. Munson's sufficient but not necessary conditions were therefore met, so neither IME said there was major contributing cause based on those conditions being met. The JCC was required to appoint an expert medical advisor in this case. Dr. Munson testified only a few days before the merits hearing. The EC contended that the medical testimony evidenced that the accident was not the major contributing cause of the claimant's condition. The JCC found otherwise and created the conflict in his own order. Because the JCC created the conflict in his final order, there's no opportunity to preserve that issue short of an appeal. I think a rehearing, as I fleshed out in my brief, a rehearing would have been fruitless because the JCC specifically met that issue head-on, said no EMA. The claimant does not due any indemnity benefits because those benefits emanate from the claimant's improper use of self-help, which I've already described. No TPD benefits are due because the employer continued to offer a job, and I believe that testimony was undisputed. The claimant voluntarily resigned, and but for his own resignation, that job would have continued to stay open. I think for those reasons, the EC meets its burden of proving no indemnity benefits under the recent Toscano case. In conclusion, we ask that the Court do the following. 1, find that the JCC had no jurisdiction over medical issues. 2, reverse the JCC's award of benefits. And 3, to the extent that this Court finds that there was jurisdiction over medical issues, remand and instruct the JCC to appoint an expert medical advisor.
Does your position affect the issues on cross-appeal as to the ratings of the total, permanent, partial disability and things of that kind? The managed care requirement doesn't apply to those findings, does it, or does it?
I believe there are a couple issues on cross-appeal. One is with regards to the period of TPD benefits awarded. There was about a month discrepancy.
Yes.
So I'm not sure I understood that question.
But those issues are totally separate from the ones involving the medical benefits, correct?
Right.
Okay.
Managed care arrangements, to the extent that the Court says no jurisdiction for medical issues, that applies only to medical issues.
Okay. That's
Thank
all
you, Your
I need.
Honors.
All right. Ordinarily, I would ask you, Mr. Urban, if you wanted to reserve time for rebuttal on your cross-appeal, but counsel...
No, I do not.
Okay. All right. Well, then, let's just proceed then.
May it please the Court, my name is Richard Urban. I represent the claimant, Appellee Cross-Appel Line. Seated with me at the council table is Mr. Monty Shoemaker, who is a trial attorney on behalf of claimant. From the date of the accident, July 8, 2008, claimant made continued requests to his employer for the authorization of medical care. Now, the law is clear that notice of an injury to an employer is also notice of an injury to the carrier. There is an indivisibility of separate entities here. There is a unity of the two. So from that particular date, the carrier is deemed to have imputed knowledge of the injury. Although claimant's testimony was somewhat in conflict by Michael Hart, who was the employer, the JCC, acting as finder of fact, determined to accept the testimony of the claimant over that of the employer as to claimant's notice to him of his injury and his request for authorization of medical care. Those requests went unheeded until claimant filed his first petition for benefits, which was on January 12, 2009. The employer carrier responded by making a total denial of that particular claim. Among other things, it said that the wrong employer was named the Travelers, who was indeed the carrier. instead of statewide extradition, a leasing company, AMS Leasing, had been designated as the employer. Nevertheless, claimant filed a second petition for benefits on February 13, and that petition for benefits was the subject of the final hearing, in which the JCC determined that the MCA, or managed care arrangement structure, had been defaulted. Now, in my judgment, this case is controlled by this Court's opinion in Beggin. If you will compare the facts in the Beggin case with the facts in this, in Beggin, 2 letters were sent to the employer carrier's adjuster by the claimant's attorney requesting medical care, one in January of 2001, to which the claimant received no reply, and the second on April 2001, also with no reply. A petition for benefits was then filed the following month on May 21, 2001. This Court considered that the second request for care was tantamount to a grievance, and because of the employer carrier's failure to respond to it within the 7-day period required by the applicable rule, the Court deemed the grievance procedures to have been exhausted, thereby permitting the filing of the petition for benefits, over which the JCC then had jurisdiction. Now, compare the facts in the present case with those in Beggin. A period of 4 months elapsed from the first request for medical authorization until the petition for benefits in Beggin was filed. In our particular case, repeated oral requests or initial requests for such care were made by the claimant, as found by the judge of compensation claims, and culminating, first of all, with the second petition for benefits filed on February 13. So we had finally, 7 months after the first request for authorization of such care was made, finally we had a petition for benefits filed in February. The JCC, citing Beggin, apparently took the position that the initial requests made by the claimant were verbal, and there's no requirement that initial requests under the rule be in writing. He apparently must have decided by his reference to Beggin that the first petition for benefits, which was denied in its entirety, constituted a written grievance. And then he determined, based on Beggin, that he had jurisdiction because of the lengthy and protracted failure by the employer carrier to provide any authorized care to claimant, that he then assumed jurisdiction over the medical claim as of the filing of the petition for benefits as of February 13, 2009, which, I said, was 7 months following claimant's repeated requests for medical care. Now, the statute clearly, Section 440.134.14, clearly places the responsibility on the employer carrier to make full and fair disclosure of the existence of a managed care arrangement to the claimant. And Rule 59A 23.009 requires the employer to display a telephone number in a prominent location for an employee to be able to obtain information about the existence of a managed care arrangement. Claimant's testimony was unrefuted that he was never made aware of the existence of a managed care arrangement, and indeed the employer, Michael Hart, confirmed claimant's testimony in that regard by saying that he knew nothing about a managed care arrangement either. Certainly there was no telephone number, there was no means of access for a claimant to get this information. Under the circumstances, the judge of compensation claims correctly ruled it didn't matter whether the claimant may have processed a prior workers' compensation claim with a different employer that was governed by a managed care arrangement, because the duty to inform claimant of the existence of a managed care arrangement was clearly placed on the employee in this case, on the employer in this case. Which
in the Bagan case, however, Judge, didn't the claimant, in fact, begin to follow the grievance procedures?
Did he at that point?
Yes.
No, he did not, Your Honor.
In Bagan, did he not?
He delayed he never filed a formal grievance. The JCC apparently determined that he filed a de facto grievance.
Okay.
But
in this case, there was no de facto.
I'm sorry?
In this case, there was no de facto, even a de facto grievance. Is that correct?
Well, I'm not sure about that, Your Honor. I think in Bagan, there was no formal grievance filed either. However, this court construed the second written request for medical authorization to be tantamount to a grievance. And that apparently is what the JCC in this case concluded, that the first petition for benefits filed on January 12, 2009, which was denied in its entirety by the employee carrier, was tantamount to a grievance. Thereby
the idea of the grievance is to avoid resort to the compensation system, isn't it? In this case, you're saying that the petition to invoke the workers' compensation system was tantamount to a grievance. It seems inconsistent, doesn't it?
Well, Your Honor, I don't know really what the difference is between a written request for authorized care and, in this particular case, a written petition for benefits which requested the authorization of medical care. I mean, it's clear that in both cases, the authorization of medical care was requested and denied. And in fact,
it was requested within the jurisdiction of the workers' compensation.
I'm sorry, Your Honor, I'm having a little
It was requested within the jurisdiction. It was filed like any other claim, correct? It was yes, like any other claim, and the MCA had nothing to do with it. I mean, the fact is that the position is that he knew it was that his employment was under an MCA, and he went to court instead of going to the informal, out-of-court procedures complied with, isn't?
Well, I suppose the question then is whether the judge of compensation claims interpretation of the law was correct or incorrect. Can an employer simply sit by for a lengthy and protracted period of time, ignore numerous requests for medical authorization, do absolutely nothing, and then when those verbal requests are ignored, the claimant, feeling that he had no other recourse, went out, hired an attorney, and then the attorney, not aware, and indeed the record shows that the claimant was not aware of the existence of a managed care arrangement until this informational package was sent to him by the employer carrier on February 17, 4 days after the second petition for benefits had been filed. Now remember, the timing of this is very important because the JCC determined that as of February 13, the filing date of the second petition for benefits for medical care, the managed care arrangement procedure had been defaulted because of that protracted and lengthy, unexcusable delay in care by a
But
claimant.
but wasn't that in turn based on the finding or the fact that the claimant was not aware of the existence of the managed care arrangement? And when I inquired of your opponent, he said that there had been a prior accident on this job and that he had undertaken the MCA. Is that correct?
Not with this employer, no, sir. No, sir. He had no managed care arrangement with this, with a prior claim with this employer had ever been involved. And so we had, and the law clearly places the responsibility on the employer carrier to notify the claimant that a managed care arrangement is in place, and there is a procedure outlined, a grievance procedure, by which the claimant should be advised from the very outset of his injury as to how to grieve these injuries. However,
Well,
the
what about counsel's fallback position is assuming that up until the time he got the packet, he didn't know about the MCA, and then he couldn't waive anything. How about the benefits awarded after his knowledge of the existence of the MCA and his...
The benefits awarded?
Yes.
I really don't understand the court's question in that regard. The benefits were awarded well after that particular date. The order on review was entered in March of 2010.
No, I'm talking about if there were any medical expenses incurred subsequent to the time that he got the MCA packet.
You mean when he went out and appropriated self-help with physicians, I believe, yes, in the state of New Jersey? Is that what the court is referring to?
Depending on what the time...
Of course, that care was awarded retroactively to, say, the care of Dr. Sharma, which was undertaken, I believe, beginning in October of 2008. But there was simply, I mean, obviously, until the order came down, it wasn't the subject of an award. If the court agrees, then, or the next issue is whether or not, if the JCC correctly ruled that the MCA procedure was defaulted, then was the major contributing cause of claimants' cervical and lumbar conditions the result of the work-related accident. Now, I wanted to call attention to the court that the JCC's refusal, there were two, the medical evidence shows that two new injuries were suffered as a result of the work-related accident. One was a cervical disc herniation at the C7-T1 level, and a lumbar disc herniation at L3-4, the latter being the location of the surgery performed by Dr. Donnell on April 8, 2009. Therefore, if this court were to reverse on either of the two issues that the employer carrier has raised, i.e. either the major contributing cause issue or the refusal of the judge of compensation claims to appoint an expert medical advisor because of conflict in the medical opinions, the the court's reversal would affect only the JCC's findings as they pertain to the cervical injury.
Mr. Irvin, you're about a minute and 40 over your time at this point, so you need to wrap your argument up if you can. And you're out of time, but because Mr. Irvin went over, we'll add another minute and a half to your rebuttal time if you'd like to use it. No, to counsel's time.
I'd just like to add a couple things. First of all, this was never a total denial. This was a compensable injury, and the employer carrier accepted the compensability. Mr. Irvin made a few representations about there being repeated oral complaints by the claimant to the employer. However, that is very different from actually sending something in writing to the employer carrier as they did in Bagan. The claimant never did that in this case. Furthermore, the initial...
When did the claimant first advise the employer of his injury?
Well, he said he called him the day of the accident, and that's what the JCC ultimately found. Furthermore, there was mention of the initial petitions. The initial petitions were against the wrong employer. So I don't think that – I think it was improper for the judge to determine that those were, in fact, I guess he called constructive grievances or written grievances.
Was the second petition for benefits against the correct employer?
There was a first one that was the wrong one against the wrong employer. There was a second one against the wrong one. It was actually the third time that he got it right. That's when the carrier responded. That's when the carrier sent out the packet 4 days later. Finally, Judge Schwartz mentioned some issues regarding the managed care arrangement, whether the JCC has jurisdiction. No, the JCC wouldn't have jurisdiction over medical issues. However, the indemnity benefits flow from those medical issues, the improper use of self-help. So in that respect, that issue would also have to be revisited. Thank you, Your Honors.
Thank you, counsel, and thank you, both counsel. The court will be in recess.
Can I ask
yes,
one last question?
Of course.
Is there any evidence, is there evidence that he did not know of the existence of the managed care arrangement until he got the packet?
That he did not know of the arrangement?
Yes. He said he didn't, I gather. Is that true?
The judge accepted his testimony.
Okay. Thank you. Thank you.